The following IWLA webinar, Warehouse Legal Liability, was recorded on July 30th, 2013. All information is accurate as of that date. Good morning and welcome to IWLA's Warehouse Legal Liability webinar, scheduled to run between 11 a.m. and noon Central. My name is Joe DeGuzman, and I'm the Senior Coordinator of Member Marketing for IWLA. Today it is my pleasure to introduce our featured speaker, Mr. Mike Lopman. Mr. Lopman is the Division Vice President of Artex, has taught warehouse legal liability at IWLA seminars, and keeps current in the required changes in forms, rules, and regulations. Before we begin, I'd like to quickly address protocol for the webinar. During the duration of the webinar, all participants will be placed in lecture mode and all participants' lines will be muted. To collapse the interface window on the right-hand side, please click on the orange right arrow. If you minimize that application, you will no longer see the presentation. At the end of the presentation, there will be a Q&A session. Please submit your questions in the questions box in that user interface window. If you have any technical issues, please use that questions box also, and I can respond to you directly. This presentation will be distributed via PDF format either later this afternoon or tomorrow morning. With that, I'd like to hand over the presentation to Mike. Mike, go ahead.
Great. Hello, everyone, and thank you very much for taking time out of your day to join us here today. I hope the information that I provide you is informative and useful to you down the road. Over the past several years on an annual basis, I've been conducting and doing this webinar for the IWLA. And the question sometimes arises, why do we need to talk about the basics of warehouse legal liability on an annual basis and refresh ourselves with it? The answer to that is quite simple. The warehouse legal liability policy is what is known in the insurance industry as a marine policy. Which is entirely different in the way that policy is regulated as compared to other casualty policies. If you might be familiar with a workers' compensation policy, an automobile policy, or a property policy, those types of coverages are regulated by the various state insurance departments, meaning that they approve the wording and the coverage agreements, the exclusions, the terms and conditions of the policy. A marine policy is not regulated by the various states' insurance department, which basically means that the individual insurance companies are free to write the policies with the insuring agreements, exclusions, terms, and conditions that they wish to have in their particular policy. They, in turn, when they write that policy, submit it to the insurance departments for approval for just their own insurance company, which basically means that if you're looking at insurance company A, B, and C insurance companies will have different legal liability policies with their terms, conditions, and insuring agreements. So oftentimes when you compare these policies and you look at the cost of the various policies, you might see one that is substantially higher or substantially lower than the others. And oftentimes this is because the terms and conditions and the insuring agreements and that those policies differ. So it becomes extremely important that you drill down and become familiar with what type coverages you need for your operation in order to best be protected. So with that said, we're going to get started here. And let's talk about the warehouse legal liability policy. It provides coverage in the event the warehouse operator is negligent and results in damage to goods. And recovery in this policy is limited to identifiable measures of damage identified on a warehouse receipt or contract. It's extremely important that when you have your warehouse policy in place, that you have your backup information and contracts or warehouse receipts to substantiate how a loss would be settled. The reason for that is if you are storing a customer's good and a loss does occur, one of the first things the adjuster is going to want to see is the loss limitation on the warehouse receipt or the contract that you have. Without either one of those items, the adjuster is not able to adjust and pay for the claim accordingly, which is going to result in extremely long delays in the settlement of the claim, which eventually leads to a very unhappy customer. First party versus third party coverage. We, meaning the insurer, will pay all sums you become legally obligated to pay as damages except punitive or exemplary because of your liability as a warehouse operator or bailee for the loss or damage to personal property of others. A couple important things in the comments right there. Legally obligated, which basically means that you are responsible via the warehouse receipt or the contract that makes you legally obligated. I'm also going to drop down there and as a warehouse operator or bailee. It's important to note, and going back to my comments earlier about the terms, conditions of policies, that some warehouse policies do not contain the terms warehouse operator or bailee. They may only contain one of those, warehouse operator, and leave the word bailee off. So these are the type of things you need to look for when you're actually doing the comparison of policies. And to drop down a little bit farther, the comments, while such property is in your care, custody, or control and located on the premises listed in the declarations that apply to this coverage. Care, custody, and control. That is how they will determine whether or not this policy is triggered in the event of a loss. Now, what I caution you against, and what we see sometimes in the industry, is that you may have a warehouse operation where a customer asks you to store certain goods and you do not have enough room to store those goods. So therefore you may ask a friendly competitor if they have space available to put those goods in their warehouse for you. Remember, once those goods move into that warehouse, they are not under your care, custody, and control, and therefore the warehouse policy would not respond in the event of a loss for goods that are stored in a facility that you do not have control of. However, the policy can be amended with what we call 4PL coverage. And so again, if you're doing some type of storage of your customers' goods where you do not have care, custody, and control, you need to review your policy to see if it does have the 4PL coverage on it to protect your interests. Warehouse legal liability is thought of first-party coverage. This is incorrect. The insurer is not providing protection for damage to your customers' goods. They are providing liability coverage for you in the event of property damage to your customer's good. Liability coverage. Now, what often happens in the industry is your customers think of warehouse legal liability as a coverage for their property that is in your care, custody, and control, and that your policy will respond to pay the total value of those goods in the event of a loss. This is why I go back to my comments earlier about needing a warehouse receipt or a contract in place that specifically points out how a loss is to be adjusted in the event that loss takes place. And again, it's extremely important to make sure that all these documentations are in place. It's also important to review the contracts that your customers ask you to sign for their goods. I would strongly suggest that you make use of the IWLA counsel, Kevin Phillips, to help you with this. The reason for that is that so many of these contracts are put together by very good contract attorneys. However, they do not have any idea how the commercial code is or how the warehouse policy responds. Therefore, they may ask for things in those contracts that are detrimental to you or may even limit your ability to have a loss paid in the event of a loss. A warehouseman is liable for damages for loss or injury to the goods caused by their failure to exercise such care in regard to them as reasonably careful man would exercise under like circumstances. This comes from the Uniform Commercial Code, and this is going to be the basis by which a loss is determined by the adjuster and whether or not it's payable under the warehouse policy. Damages may be limited by a term in the warehouse receipt or storage agreement, limiting the amount of liability in the case of loss or damage and setting forth a specific liability per article or item or value per unit of weight beyond which the warehouseman shall not be liable. Again, from the Uniform Commercial Code, and I go back to my comment a minute ago about contracts. There are times when contracts are put before a warehouse operator that call for the warehouse operator to be responsible for 100% of the damaged goods. What your customer is actually trying to do in that particular case is shift the cost of their property coverage to you. Basically, when you are storing the goods there, the customer should maintain property coverage on those goods that are being stored for any damages to those goods that does not arise out of your negligence as such. But by trying to force in a contract you to be 100% responsible for those goods, all they're basically doing is shifting the cost for their property coverages over to you. What do you look for in a policy? Insurance companies write policies that give you coverage and take it away throughout the contract via exclusions as such. Important parts of the contract: coverage and insuring agreement. This is the language in the contract that establishes the parameters of the carrier paying the claim. And again, I go back to my comment earlier where this not being a regulated policy, they can change wording in this insuring agreement that limits how they may view you as a claim. What that limitation does would drive down the cost of the coverage, but also leave you still vulnerable to other claims. Exclusions: the language in the contract that limits the insurer's responsibility in the event of a loss or completely takes away coverage for certain items or claims. Every policy, regardless of whether it's warehouse legal, general liability, auto liability, all contain exclusions. It's important for you to work closely with your insurance representative to review these exclusions to see if any of them would affect you. A typical exclusion that we see in warehouse contracts might include infestation. Well, certainly if you're doing food-grade products within your operation, you would want to have infestation as part of your coverages. These exclusions in the policy can usually be purchased back for additional premium. What it does not cover: typical exclusions include, but are not limited to, the items I have listed here on the show. The items in blue: accounts, bills, currency, government authority, nuclear device, war, are all standards exclusions on all policies. They are the type of exclusions which under the warehouse policy you would not be able to purchase back and have the exclusion removed. However, if you look at the other exclusions that are listed there in kind of the brownish colored lettering, those are often included within the exclusions, but some of these can all be purchased back for additional premium dollars. So again, it's extremely important to go through those exclusions, see which ones are applicable to you and which ones you would need to purchase back in order to make sure that you are fully covered by the policy. Other exclusions that you can look for: inventory shortage, contamination, loss or damage result of missed shipment. All of these are typical exclusions, and if you note, the very last one is the one that I mentioned earlier, the 4PL coverage. So that is typically excluded as well in the policy, but would need to be purchased back if you do have goods in the care, custody, control of an additional third party because they are not in your warehouse. Insurance fallacies for the warehouseman to avoid. Warehouse legal liability insurance will cover all losses associated with the depositor's product. This is a fallacy because it will not cover all losses associated with the product. It only covers losses for which are a result of your negligence. And again, many of your customers may not understand this, so it's extremely important that in your contract or the warehouse receipt, when you are discussing terms, that it is pointed out to your clients so problems do not arise down the road. A warehouseman can elevate its duty of care with respect to a depositor's product without consequences. There would be consequences to that, and I go back to the contract again. There are sometimes items within that contract that you sign that may obligate you for other items that are not covered within the warehouse policy or any other of your insurance policies. So you need to be extremely careful in what the customer asks for, especially if they're trying to elevate your responsibility. This is where an attorney can be extremely helpful. It is not important for a warehouseman to limit his liability with respect to a depositor's goods. It's extremely important that you limit this liability, and this limitation is written either in the warehouse receipt or the contract, because as my comments earlier mentioned, without that limitation, without that documentation, if a loss does occur, the adjuster does not have any means to adjust the loss and pay for the goods. So it would be a very long drawn-out process, and I'm sure your customer would not be happy with it. It is not important for a warehouseman to issue a warehouse receipt contract. I think we've gone over this enough. It's extremely important that this take place. The last item there, a warehouseman can name the customer as an additional insured. It's funny that we have to put that on there, but I've seen many contracts over the years, again written by very good contract attorneys, where they go down through there and they say you must maintain workers' compensation, you must maintain general liability, you must maintain warehouse legal liability, and on all of the above policies, our client A, B, and C is named as an additional insured. Well, that's all in fine with the workers' compensation, the liability coverages as such, but by naming the warehouseman, or by naming your customer as an additional insured, they are now an insured under the policy, which basically means that if you as a warehouseman damage their goods by your negligence, they are no longer able to file a claim because they are no longer a third party. They are a first party. And the warehouse policy only covers third parties. So you should never name a customer as an additional insured under a warehouse policy. Presentation of a claim, its timeliness. The contract's provisions in the policy can negate coverage in the event the insurer was not notified in a timely manner. Now, the definition of timely is really up to the discretion of the adjuster. Some things that should be reported extremely quick that you know about would be a forklift operator knocks over a sprinkler head and starts to flood your facility, damaging the products. Those type of things are known immediately. Something that may not be known for months down the road might be infestation. You may have food-grade products that are stored there waiting for some seasonal time of which the goods are shipped out. In the meantime, 6 months or earlier, your product became infested with something that destroyed it. Well, the key here to actually presenting a claim is the minute you know about a claim or even a potential claim, you should notify the insurer, because you can notify the insurer of a potential claim for information purposes only, and that means that you've now you've met the obligation of the policy. You do not have to have all the documentation, but it's simply a matter of notifying the insurance carrier's adjuster that you think you may have a potential claim, and so you're providing that information to them to actually create a file, but not to do anything about it until such time a claim is actually, or damages are actually discovered. The claim process can be influenced by how the claim is presented to the carrier. So as we look at this, let's talk about, the water damage claim as such. A minute ago I mentioned how a claim could occur where a forklift operator might hit a sprinkler head and the water comes out and damages the goods. Well, how you present that claim could mean the difference between whether or not the claim is paid immediately or whether or not it's drawn out. Oftentimes I've seen people or warehouse operators report the claim, and the adjuster asks what happened, and you say, my warehouse has been flooded. Boy, I'll tell you what, floods are not covered under the warehouse policy. So he's going to take all this information down, and then about 2 weeks later you're going to get a nice letter saying, I've looked into the policy, flooding is not covered, and therefore we are denying the claim. So now you've got a problem where you've got to get back to the adjuster and talk it through again as such. So you need to be very specific about how that damage was done by telling the adjuster that your forklift operator was negligent in hitting a sprinkler head that damaged your customer's goods. That's going to get an entirely different reaction from the adjuster versus we just had a flood. So think about how you present the claim, as it can influence how the adjuster reacts to it. Insurance rates, keeping costs down. Many warehouse operators will pay for losses that incur under a certain level, say $5,000, $10,000. The interesting thing about the warehouse policy is it can have multiple deductibles. An example would be you've decided that for your best interest, a $10,000 deductible is what you want. However, if you do not read the exclusions or the terms and conditions of the policy, you may not realize that that particular policy may hold a $25,000 deductible for mysterious disappearance. So you need to check again when you're looking at the various policies, terms and conditions to see whether or not they have secondary deductibles that could affect you. Another deductible that is often enforced and often overlooked is if you are storing high value or high targeted items, cigarettes, liquor, things like that. Your policy may have a $5,000 or $10,000 deductible for general goods, but there's going to be some sort of a limitation on high targeted valued items, and you need to negotiate with your insurance carrier to make sure you have not only the proper limit but the proper deductible for that. The insurance carriers will give credit for higher deductibles, but there is a crossover line. And that's where the third point is. How many years of property insurance premium savings would it take to equal what you would pay out of pocket with a higher deductible? So there's that crossover point where you may have a $5,000, $10,000, or $25,000 deductible that will save you a substantial amount of money on the policy. However, going from a $25,000 deductible to a $100,000 deductible may only save you a few pennies a year. So therefore, taking that additional $75,000 risk just isn't worth it. The last item, know what you sign. They're going to make you, the insurance company is going to request that you sign an application, and you need to make sure that you are thoroughly appraised by your insurance broker as to what you are signing. Legal and property premiums are based upon age, construction, protection, property location, property maintenance, appearance. These are all important items, and all of these will go into the formula not only when the underwriters look at your property coverage, but also your warehouse legal liability coverages as well. I'm switching here a minute to the cargo coverage, and the reason I'm switching over here, I've got two different items here, bill of lading and contingent coverage. The question arises at times, when does the warehouse legal liability policy become enforceable versus my cargo policy? So typically you will have goods delivered to your warehouse facility and on the dock. As long as those goods are still under the bill of lading, basically meaning that you have not accepted those goods for storage, even though they may be sitting on the dock or actually being loaded into, moved into your warehouse. As long as they are still under the bill of lading, it's considered cargo coverage. Once the bill of lading is done and you've accepted those goods, it moves over to warehouse coverage. So the second item there is contingent coverage. We sometimes find warehouse operators who may need to move goods from one building to another that they own as such. In times you may hire a third-party transportation coverage company to move those goods. So you may need the contingent cargo coverage where the goods have been moved out of your warehouse. They are under a bill of lading for the transportation company, and the transportation company does not have a high enough limit on their cargo policy to cover the value of those goods. So that is where a contingent cargo coverage would come into play, that if they damage those goods and do not have enough coverage to pay for the damages, you can have a contingent cargo coverage in place that would pick up the difference. I would also caution you that if you are using any type of third-party transportation company, that you always make sure you have an updated and viable certificate of insurance on file that shows that they are properly insured for workers' compensation, general liability, auto liability, cargo coverage. Because those goods are going to be, you could be held responsible for some actions of those trucking companies. So you want to make sure that their limits are high enough to not only protect them but to protect you as well. And I would also ask that you ask the transportation company to put you on the policy as an additional insured. Freight broker operation. Do you act as a freight broker? How do you present yourself to your customers? This is a very interesting topic that we've had quite a good bit of discussion within the insurance company that many of you may be familiar with, the captive that the IWLA has in place for some of its members. Freight broker liability becomes a very scary thing, because if you are acting as a freight broker, there's a direct line back to you to be held responsible for any losses that may occur when you use third-party operators and you've placed the freight with them. So again, if you're going to operate as a freight broker, you need to know who you are doing business with. The second item there is, how do you present yourself to your customers? I see a lot of websites where warehouse operators talk about having the entire package, meaning that they can store it, they can do the value added, they can do the repackaging, and they can also provide coast-to-coast transportation. We caution you with that, because you could be setting yourself up for some very serious losses when you present yourself as something in which you use third-party people, operators, in order to fulfill those needs of your customers. So take a good look at your website and make sure that you're not promising a little bit more on that website than you can deliver. Good business management techniques are always the best way to keep costs down. You can control the claims that incur in your side of your walls. Training and safety. It's always comes back to those items that the best thing you can do is to try and eliminate losses that occur within your warehouse operation versus worrying about how that loss is going to be paid. Warehouse legal, coverage, exclusion, and valuation issues should be reviewed prior to the acceptance of the policy. I would suggest that if you are going to look at various insurance carriers to provide your warehouse legal coverage, that you ask your insurance broker to obtain a sample or specimen policy form, so that both you and your broker can go through those terms and conditions to make sure there isn't something there that could come back and haunt you at a later date. Comprehensive. Customer certificate requirements will call for a comprehensive liability policy. And they will send these out, and they will ask for your most current general liability policy. Does it meet the criteria for being comprehensive? They will ask if your warehouse legal policy is comprehensive. These are the types of terms and conditions. Before you respond, you really need to have outside counsel's advice on how you should respond, because oftentimes the courts look upon these terms to mean they will be all-encompassing, even though your policies are not all-encompassing, and therefore you could find yourself in a situation where you will have to pay out-of-pocket expenses for a loss because of the agreements or the terminologies that you've accepted from your customers. I brought up here a little bit as part of the property contract business interruption. The reason I bring this up is because, again, oftentimes customers will try to put in contracts items that they want you to cover in the event of a loss. If a loss occurs, transportation to the secondary location, ongoing business expenses, different things like this that customers should actually have already included in their business interruption. But these are things that you should also be looking at in the event in your property policy. If a loss occurs, do you need to continue your payroll? Do you need to have a secondary location, and what kind of ongoing business expenses? Again, these items are items that you can review with your insurance broker. Completed operation. How does your policy respond to your value-added services? Now let's think about the general liability policy for a minute. The general liability policy provides coverage for bodily injury and property damage as a result of negligence. Now, if you are repackaging goods and if you are actually managing the entire process of your customers, making sure that items are shipped out before expiration date, these kind of things, as long as your general liability policy contains products and completed operations, you should be covered for most incidences that occur in the event of a loss because of your value-added services. But you should review this coverage, your general liability policy, with your broker to make sure you do have products and completed operations. I have seen policies in the past where the insurance carriers do not think you have an exposure to these type of losses. Therefore, the only policy they provide you is what they call premises operation, which should handle any loss that would occur on your premises for bodily injury or property damage, but would not protect you for a loss that would occur outside of your operation due to your value-added services as such. This is a time, too, I want to bring up another point concerning the general liability policy. The warehouse legal liability policy, as mentioned early on, covers you for goods that are in your care, custody, and control. Therefore, the general liability policy excludes any loss for goods or loss, bodily injury or property damage, in your care, custody, or control. So you do not have coverage for a loss for your customer's good under the general liability policy. But more importantly, there is one piece out there that could hurt a warehouse operator because of this care, custody, and control exclusion under the general liability policy. We find often that a warehouse operator will either lease or rent property. In other words, they are not the owner of the property, they lease or rent the property. And they sign a lease or a rental agreement with the landlord. The landlord, in his contract that you sign, says that you agree to be responsible for any damages to the property caused by you by your negligence. What kind of damages could occur? A very simple one. Again, a forklift operator hits a supporting pole of the roof, knocks that pole out, and part of the roof collapses. Well, many people think that that's covered under the property damage of your general liability policy. That is not the case. That loss would not be covered at all because you are actually in the care, custody, and control of that property. That's an exclusion under the general liability policy. Another example would be you are renting or leasing a facility that has a lower level. You overstack goods in a particular place and the floor collapse. Again, that would not be covered under your general liability policy because of the care, custody, and control exclusion. I suggest you go back and read any lease or rental agreements that you have. Where is this coverage found? It's found with the landlord. The landlord's policy should respond to this, and that's where the protection should be. Therefore, that clause in your rental agreement or your lease agreement should be removed, and therefore you would not be held responsible for that. as such. Now, perhaps there's some sort of a payback or something agreement that you could make with the landlord in covering the deductible of the policy. But this coverage should be covered by the landlord, and you should not have a contract that requires you to pay for it. Pollution. This is something that often warehouse operators do not think about, but what was your customer's product turn into at 500 degrees? One of the more scary items is that warehouse operators will accept goods in their warehouse, and they think they have an idea of what those goods are, but yet they do not. And in the event of a loss, the fire department arrives and will ask you what is in there, and if you're unable to tell them, you may be watching your entire place burn down, because they may not start fighting the fire until they have a better understanding of the goods in your warehouse. It's very important that you keep track of everything coming into your warehouse and how it would affect not only your operation, your customers' other customers' goods in your warehouse, and even the neighborhood around you. An item here, your carrier. How is your carrier rated by AM Best? Does your carrier have other logistics customers? Do they have a warehouse legal liability form? Or have they told you that a property of others coverage works in a property form? Quite a few items here. I'll start first with the AM Best rating. Any insurance company that you deal with should be a class 7 or 8 or higher. Now, what the classes are is the financial size of the insurance carrier. If you're dealing with somebody that's a 7 or higher, you usually have you do have a much larger insurance carrier that to pay for the losses. The rating of it, you should always deal with a carrier that is no lower than an A-. A-, A, or A+ is preferable. We all sometimes see carriers that are rated B or B+ or C even. Stay away from those. Stay away from those, and that's why it's so important that you get certificates of insurance from any vendor that you deal with, especially the transportation vendors, to make sure that they all have an A- or higher rating from their carrier, and that will show on the, you can ask them to show that on the certificate. And if not, then I would suggest that you no longer do business with those customers, because if a loss occurs, it could put you in a very precarious position. Warehouse form, the legal liability form, do they have it? There are specific insurance companies that have operations in their marine department where their underwriters have very good working knowledge of the warehouse form and the terms and conditions in that form. There are other insurance carriers in their marine division where they underwrite such things as cargo or equipment floaters, and they just happen to throw this warehouse application over to that person who has very little working knowledge of it. So you need to go back and find out whether or not the company you're dealing with does have experienced underwriters in their employ. And the last item there on this sentence, property of others. I see this all the time, and it just absolutely sends shivers down my spine. Your customers say, I need to be fully insured. You've got to, otherwise I'm not going to do business with you. So someone advises you that put this coverage under property of others in your property policy. Well, let's talk about what happens here in the event of a loss. Under the property of others form or endorsement under a property policy, you do not have the protection of the Uniform Commercial Code. So what does that mean? That basically means that if your customer fails to pay you, you do not have the legal rights to take those goods and eventually sell those goods. The courts could actually tie you up for years upon end if your customer failed to pay you for those. Eventually, if the customer went out of business, you may find such creditors as the bank demanding that you continue to store those, and that eventually they will take those goods and they will sell the goods, and you will not recoup any money from them. So that becomes a very dangerous thing. The other item that I think is extremely important is that the warehouse legal liability policy has legal protection in it. They will defend you for losses within that policy. Your property carrier does not have the right to defend you. So basically, if you are covering goods under property of others, let's say for $500,000, because that's what the customer wants, a loss occurs, the customer comes to you and says, oh, you only had $500,000, but we gave you an additional shipment, so I want $600,000, or I'm suing you. That dime is on you. You will not have the protection of the insurance company to fight for you in those type of situations. Any legal expenses will be covered by your out-of-pocket contributions.
Thank you for listening to this IWLA webinar. For more information and for more webinars, please visit IWLA.com.